The Honourable David Parker.
Thank you, Mr Speaker. Can I begin my contribution by saying that I was pleased that in the committee stage of the House, Parliament chose to reinsert into what is now the Senior Courts Bill the provision that expressly set out that we have sovereignty of Parliament. That provision was in the former Supreme Courts Act, and it was put in there to emphasise that courts are not meant to be writing law, they are meant to be applying and interpreting law, and obviously they have to fill a void if there is a gap in the law, but that they shouldn't usurp the role of Parliament. There was a view that it didn't sit naturally in the courts legislation, and if it was in a constitutional provision, it ought to have been sat in the Constitution Act. And so the government at one stage said it was going to remove that particular clause from the legislation, and indeed it wasn't in the first reading or indeed recommended by Select Committee on report back from Select Committee, but rather leave that issue to be dealt with in the Constitution Act at some later date, which would have left a gap in the law. Retiring Supreme Court Judge Sir John McGrath, as he left, made the point that that was wrong. Others, including myself, made the point that whether or not that provision was originally necessary in the Supreme Court Act, the fact that it was there but was no longer there had to have legal meaning, which meant that the law was changing by the omission of that clause, probably, and therefore we would have been undermining the sovereignty of Parliament if we hadn't kept that clause and carried it forward from the Supreme Court Act to this legislation, which we've now done. Can I thank Richard Corns, who's an expat Kiwi now living in the UK, who also provided advice to the Select Committee on this issue and advocated for its inclusion in the legislation. And I think it's better legislation for restoration of that clause, sir. Can I deal also with something that my colleague Jacinda Ardern mentioned, which is the compulsory age of retirement for judges? The only thing, and I share her concern that age is not generally a proxy for competency, but there is one difference between senior judges and employees, and that is that they don't have an employer. And so if you get a doddery old judge who's losing his marbles or her marbles, it can be pretty hard to get rid of them, because if they are stubborn and unwise enough to stay on, the only way you can get rid of them is actually through this Parliament moving to get rid of them, and that's a very difficult and rarely used thing to do. So I think that that was probably in the mind of those who favoured a compulsory retirement age, because it is pretty... What's that? Well, MPs actually are only elected for a 3-year term, and if a doddery, senile MP stands for election, the people are generally wise enough to appoint someone else. Well, materia Toure indicates that that's not always in the case, and that we've got some premature senility on the other side of the House, but I think that's a cruel blow. Mr. Speaker, can I turn to another issue, and that relates to access to the law, because although it's good that there are some provisions in this that are improving your ability to file documents electronically so as to reduce costs and perhaps speed up processes, overall we do have a serious and unresolved problem relating to access to justice in New Zealand. Now, we've got two major spheres of jurisdiction in our courts. We've got the criminal jurisdiction, we've got the civil jurisdiction, and these bills in the main deal with the civil jurisdiction, which is why I'm going to concentrate in my comments on the civil jurisdiction. Sir, access to justice is largely a function of cost. If you can't afford to use the courts to resolve your civil disputes, you don't get to use the courts to resolve your civil disputes, and sometimes those disputes which ought to be resolved by the judiciary aren't, because people can't access them. And I've got to say that I've been a lawyer now since about 1982, I think it was, that I was admitted, the end of 1982, which is now more than 30 years ago. In my 30 years of legal practice, I have seen access to the courts deteriorate markedly. When I first was a young lawyer, people were routinely resolving quite minor disputes like traffic, car crashes, or disputes with their insurers, or disputes on the quality of workmanship, not a house that's so faulty that it's falling down, but smaller house disputes. Hire purchase transactions that were not being complied with were sued upon. Finance company, I can remember working for Wilson Neal Finance, or whatever their finance company was called, and they would sue for the last $100 due under a contract, not because the last $100 was going to make them broke, but actually because enforcing the rule of law actually encouraged adherence to the rule of law and reduced all of our costs of credit because people wouldn't just flick off and not pay the last few $100s of their insurance of their hire purchase contracts. Now, virtually none of those things are ever litigated through the courts. We do have a disputes tribunal that, in respect of the smallest of those things, can resolve disputes between people. They can't enforce debts. That's actually outside of the jurisdiction of the disputes tribunal. And there are many disputes which fall outside the jurisdiction of the disputes tribunal, and I'm not suggesting it should be increased materially because it's pretty rough justice there sometimes, but there are many disputes that are above the jurisdiction of the disputes tribunal that cannot be afforded to be litigated through the New Zealand courts. Now, I'm one of those people who, I started with environmental law, but I was a civil litigation partner in one of the largest South Island law firms, and one of the main reasons I gave up civil litigation quite a long time ago, although I've still got a practicing certificate, was because I thought that the cost of the services that I was delivering to people exceeded the value of what it was that I was delivering to them. That's even for the people who could afford it. I didn't think it was fair value, given the complexity and cost of legal processes. Sir, and in addition to those people, there are lots of people who just can't afford to access the system who can no longer get justice. Now, sir, this is now widely acknowledged by the judiciary. And I'm going to quote the last Principal High Court Judge, Justice Wynne Kelman, and she says, why is access to the justice important in the civil sphere? And her answer was, it's because access to the justice is the critical underpinning of the rule of law in our society. The notion that all, the good, the bad, the weak, the powerful, exist under and are bound by the law, that condition cannot exist without access to the courts. And then further on she says, unless we have this access, we live in a society where the strong will by any means, including violence, always win out against the weak. This will be a society in which once binding civil obligations are recast as voluntary. She observes, if the court dispensed justice for only of the few, if the court dispensed justice for only the few, what does this mean for our concept that we are a nation that exists under the rule of law? And it is increasingly true in New Zealand that individuals cannot afford to access the courts. It's increasingly true that even our non-governmental organisations cannot afford to litigate the things that they want to and should be able to litigate if they're challenging a governmental decision. So not only are disputes between citizens not being properly resolved, disputes where the government is being held to account through judicial review are rarer and rarer. When I started law, community organisations would, not every day, but quite frequently challenge illegal acts or unreasonable acts of government. You see that very rarely. EDS and Fish and Game Council had to spend many hundreds of thousands of dollars to litigate the one plan, the plan in the Manawatu, and even then the regional councils effectively thumbed their nose at them after they've spent all that money, and perhaps partly in the knowledge that they can't afford to litigate the issue. So these problems relating to access to justice will not be resolved through this legislation. I have some views that we need to simplify our civil procedure rules. We need to trust judges and expect judges to control their courts. They should be expected to dispense affordable justice. They need to dispense with they need to avoid a lot of the pre-trial interlocutory processes that so drive up cost and can be used by a rich litigant to avoid justice at the suit of a poorer party because they can effectively outspend them and delay justice and actually avoid justice in some cases, sir. Sadly, this legislation does not fix those problems.